and it's a pleasure to welcome you to our webinar, Corona time webinar, I think the 10th since the beginning of the crisis. And today we are going to talk about Israeli emergency law, which is of course very relevant to the past 2 months and possibly to the next few months. And it's a pleasure to have with us Professor Amnon Reichman, who is a principal investigator at the Minerva Center and also the head of the National Center for Cyber Law and Policy at the University of Haifa. Amnon will talk for about 30-35 minutes, and then we'll open the floor for comments, questions, protests, and other reactions. Amnon, the floor is yours, please.
Thank you very much, Eli. I will share my screen. Okay, here we go. So, some preliminaries. I want to motivate the discussion. Why is this important to look at the typologies of emergency regulation in Israel? For 3 main reasons. The one is it is important to look at it internally in the sense of the justifications offered by the State of Israel for the normative and institutional arrangements. Some of these justifications are unique, some are shared by others, and therefore it is important internally to assess whether they're justified or not. As alluded to the extent we're interested in a comparative research, and I think we are, we've heard from Stefan and we've heard from Nir Kosti, it is really interesting to compare how different jurisdictions react to the current emergency, the coronavirus emergency, but also to emergencies at large. And therefore, it is important to know what are the nuances, what are the differences that are typical for each and every regime, because otherwise some of the comparisons are irrelevant or otherwise are not. And in any event, we may also want to look at migration patterns. Some of the research is not instrumental in the sense of let's see how each jurisdiction reacts and therefore evaluate what works or what is a correlation between a specific design or specific recourse to such and such measures and the success in fighting a pandemic or war or another emergency, or the correlation between that and human rights or the sustainability of liberal democracy. And that's one type of research, but we can also look at it from a sociological or historical perspective and see migration patterns of certain models or certain regimes, how they migrate, and that's another important theme. And of course, there's always this motivation of how do we do better to the extent we can draw some normative conclusions from this exercise. Another preliminary comment very briefly, what do I mean by regulation? I mean regulation in the broadest sense. Regulation includes, in this research, includes constitutional regulation, statutory regulation, secondary regulation, decrees, orders, the entire normative pyramid. So sometimes the term regulation only captures secondary law. I mean by regulation everything basically, including, by the way, judicial decisions. They're also part of regulation, although under some models of regulation, they're not. So this is important to note. And lastly, what is an emergency? We have to have some operational definition of an emergency. So again, and that is, people who've been on this webinar, seen other episodes of this webinar already know that we think that there is a distinction between emergencies and extreme conditions. Extreme conditions are situations whereby the state operates outside the rule of law. Emergencies are captured within the rule of law. And I offer here 2 criteria for an emergency. It has to be fast evolving. It requires the deployment of relatively vast amounts of resources and acute risk, okay? And then there's the element of uncertainty. So the category is known, but we don't really know what we need to do in order to address the emergency. We do know that it will require most likely infringement of basic liberties, but we don't know exactly which measures may be needed, at what time, how to then recover from it, etc. Another preliminary comment, I'm going to basically address out of the three phases of emergency: preparedness, the actual operations during the emergency, and then recovery. I'm going to address the actual emergency. I'm not going to talk about preparedness, and I'm not going to talk about recovery, although just for the sake of time. Okay, so let's talk about the models. Israel basically has three models, 3 layers of law. And that's important, again, if you want to compare to other jurisdictions, if you want to test for what works. So you have to know which model you're testing. So the first model is basically the British legacy. The British legacy, and then again, that's not unique to Israel. We find this in the Commonwealth more generally, and by Commonwealth, I do include also the United States for that matter. The idea is you use ordinary legislation. You don't use anything emergency other than maybe the title of the legislation itself, but it's just ordinary legislation. It can be a general legislation, or you could legislate per crisis. So you could, a coronavirus crisis emerges, and therefore the British Parliament may respond with Corona law, or the US federal legislature may respond to the crisis of 9/11 with the Patriot Act. It is a standalone legislation, ordinary legislation. Sometimes it has a sunset clause, or sometimes just repealed when it is no longer necessary, or sometimes it remains in the books for ages. So it could be general, it could be per crisis. Just by way of an example, in 1945, the British legislature in Palestine, and as it was then known, enacted the Defense Emergency Regulation of 1945, which empowers the executive. By the way, the legislature and the executive under those times were the same body, but nonetheless, you know, the law, this emergency regulation, the Defense Emergency Regulation Act, Ordinance of 1945, empowered the executive to issue decrees that are pretty draconian: house demolitions, administrative detentions, confiscations of property, and that's just an ordinary law. It's called emergency regulations, but it's an ordinary ordinance. And it was then incorporated to Israeli law via Section 11 of the Government and Law Arrangement Ordinance as the very first enactment of the interim parliament of the State of Israel, which basically incorporated all existing Palestinians' law, British law. And so that's just an ordinary law. We see an earlier version of this if we look higher at the normative pyramid, an ordering council. So all the ordering councils that that Britain issued, or the Crown issued here, included also defense order of council. So you just amend the ordering council, which served as a local constitution for Palestine, and you introduce emergency measures, what we now would call emergency measures. But these are just, it's an ordinary constitutional amendment. This particular one, 1937, is the famous one because it is empowered. It has empowered the local legislature to issue an act or an ordinance such as the Defense Ordinance of 1945. And there were others. I don't have time to go into the details. We can in the Q&A. It is important to note that the Public Health Ordinance of 1940 is just such law. It is an ordinary statute which includes a section for emergency powers, Section 20. It also includes another section, Section 17, which isn't called emergency powers. Why? Because Section 17 deals with known diseases such as typhoid or the plague, whereas Section 20 includes those diseases, cholera, plague, the typhoid, but also unknown pandemics or endemics or something like that. And then it authorizes the director, it authorizes the relevant entity to declare, the High Commissioner, to declare that an emergency occurred, a medical emergency, a pandemic has occurred, and then the director of the health services can then has access to legal powers, whatever he or she may need, is there under the Public Health Ordinance. And this is the very actual legislation which we use today, the same section which we use today, amended since then, But that's just a basic structure. Then there was a lot of criticism about this structure. As the State of Israel was created, the idea was that British law is draconian. How can you empower such access to vast and draconian measures? We should be more precise about it. So then the Government and Law Arrangement Ordinance, the very basic law that was enacted by the interim parliament, authorizes the interim legislature then, later on the Knesset, to declare a state of emergency. And to the extent that such a state of emergency was declared by the interim legislature, then the government has the power to issue emergency regulations which may supersede or suspend or amend basic laws, as there was no basic laws then, but now it includes basic laws, or any statute to the extent they're not protected, to the extent there's no language that says that they're saved from such emergency regulations, for the duration of 3 months. That's a general structure that empowers the legislature to declare and then the government to enact emergency regulation. Then it was later on replaced by basic law government. This is why we can talk about basic laws that may be suspended as well to the extent they're not protected. And then the basic law government also empowers the ministers. This is a bit technical, but it's important to note, also empowers the ministers to the extent the state of emergency exists to issue emergency regulations to the extent you cannot convene the entire government. And there are conditions, there are provisos. You can issue emergency regulations only to the extent it is required by the emergency. That was later, much later, interpreted by the courts to mean that if you can legislate ordinary legislation, you may be not allowed to use emergency regulations. Maybe you don't have the authority to do that. You have to have the specific purposes of either defending the state, protecting public security, or providing essential products and services. And access to courts, retroactive punishment, and infringement of human dignities are not allowed. So infringement of human dignity, of course, was later amended by basic law human dignity to mean disproportionate infringement of human dignity. So these are the requirements. Emergency regulations, as I said, also empower the ministers directly, or may empower. Actually, I didn't say that, but I should say that emergency regulations may, if the government so decides, empower the ministers to issue decrees, and they may also empower agencies to execute. That's the most important part of it all, because at the end of the day, we usually focus on what is the law in the sense of what is the general norms that people should abide by. But from an emergency or theory of laws under emergencies, what is important is which agency has the power to execute what, not just to issue the norms, but to enforce. So the emergency regulations can also empower agencies to enforce, or emergency regulations can empower ministers to empower agencies to enforce. Why is this important? Well, let's look at the current crisis. Recall that ordinary statute, the statute from 1940, the Public Health Ordinance, already empowers the minister, in our case, the Minister of Health, to issue decrees. Decrees telling us that we cannot leave the house for more than 300 feet or 100 meters, or 500 meters, which is 1,500 feet, wear masks, not go to work, etc., etc. But the minister, the health minister, doesn't necessarily have the authority to empower the police to enforce. In order to empower the police to enforce, you have to have emergency regulations that empower the police to enforce, using police power, to enforce the decrees that were issued by the Minister of Health. And the Minister of Health was operating under model number 1. The Minister of Health was operating under an ordinary statute. Okay, so you see the enmeshment of those two models because you need the power to execute. Another example, the general security services were empowered by an emergency regulation to use surveillance methods so they can pinpoint the location of those suspected of being infected by the coronavirus. And then they can monitor who was around them for a duration of more than 15 minutes and less than 2 meters. And then they could send an SMS, a text message to those people telling them that they're now suspected of being infected as well, and they should self-quarantine. That's nice, but who can enforce that they're self-quarantined? You would need another original primary legislation to empower the police, or you need another emergency regulation to empower the police then to enforce those text messages that were issued by the General Security Service pursuant to the surveillance powers it was given under the surveillance emergency regulations. This is technical, but it is really important because when we want to monitor which emergency power was used, we have to also look very carefully with respect to the power to execute. One last example very quickly, because I have other points I have to cover, another full model I have to cover. It is the issue of demonstrations. Under the emergency regulations that were issued, the general emergency regulations that were issued, demonstrations were excluded from the basic restrictions on freedom of movement that were issued. So that's emergency regulations. But the decree that was issued by the Ministry of Health pursuant to the ordinary statute of 1940, right? This decree has placed some conditions on demonstrations. For example, the number of people who may demonstrate, or the distance between the number of people who may demonstrate, let's say 10, and another demonstration of another 10 people. Okay, so wait, so what is the relationship between the emergency regulation that says demonstrations are allowed or are not disallowed, there's no restriction on demonstration, and then the decree that says, okay, you cannot have a demonstration for more than 10 people, spaced 6 feet apart, of course, or 10 meters apart, but only 10 people. And if you want to have another demonstration or another batch of people, they have to be originally, under the original decree, another 10 meters apart. So you have to, just a side note, you see that when you use all those decrees and all those emergency regulations, the legal space becomes more dense. This is a countermeasure to the notion of law under extreme conditions. Under extreme condition, the law becomes sparse because you're operating outside the rule of law. Under emergency regulation, the law becomes denser because you have to specify exactly what is allowed and what is not allowed, and then the regulations and the decrees become much more dense, heavily populated, so to speak. So you have to reconcile the emergency regulations that say demonstrations are not prohibited with a decree of the health minister. And the idea was then that the police may not enforce to the extent that the decree will say no demonstrations at all, the police may not enforce this. And at the end of the day, a compromise was reached that what is important is the 2 feet apart. And this component of the decree that said that only 10 people can participate in a demonstration was basically dropped. Okay, so that's model number 2. Just in addition to, another addendum to model number 2, you can have ordinary legislation, but this ordinary legislation may be premised on there being a state of emergency declared by the Knesset. I don't have a lot of time, so I'll just give a couple of examples. The administrative detentions in Israel were taken out, this component was taken out of the Defense Ordinance of Emergency Defense Ordinance of 1945. I talked about that in the second slide. And it was legislated, a special Israeli statute that said administrative detentions are permitted under some conditions, provided that there is a state of emergency. 1977, again, The price controls of products and services, legislated in 1957. Again, there were some British emergency powers prior to that. In 1957, it was legislated, but again, it was premised on there being a state of emergency declared by the Knesset. By the way, the initial version of this price controls and products and services act allowed the minister to issue a decree that supersedes the Knesset legislation. Now this is no longer in force. We only have emergency regulation by the government that may supersede an unprotected primary statute. Originally, also a decree by the minister under this particular legislation was also allowed to do, empowered to do that. And there are other examples. I don't have time to go into that. I want to move to model number 3, because model number 3 is the most modern model, but it is actually premised on the original British legacy. And the idea here is that you empower ministers to issue specific or to declare specific emergencies, not a national state of emergency, just a specific state of an emergency, and you do not empower them to act notwithstanding any statute. Rather, you empower them, or you give them access to special drawers with special measures that can be accessed only under that particular specific emergency. Recall that the state of an emergency may be declared by the Knesset, but then it is a general state of an emergency. It could have been declared originally because of security reasons, and to the extent it is renewed by the Knesset, originally under the ordinance, original ordinance, the Knesset could have revoked the state of emergency when basic law government was enacted and then amended. The Knesset has to, and to this day, the Knesset has to renew the state of an emergency, and it has done so ever since. So we are, as is well known, Israel is under a constant state of an emergency, but it is a general state of an emergency. It is not specific. So there's court cases on that. The idea is that you may have a general state of an emergency and then act or issue emergency measures that are premised on another state of an emergency. So if the original state of an emergency was security related, and now you have an economic emergency, you can issue emergency powers because a state of an emergency is a state of an emergency. This is different. The idea is that ministers may issue specific emergencies and then have powers or access to measures that are only relevant to that particular emergency, and for a short duration of time, 7 days, let's say, until they have to go and get further permission from the legislature. By the way, under model number 2, emergency regulations also must be placed on as part of the schedule of a specific Knesset committee, the Security Committee of the General Security and Foreign Relations Committee that must supervise those emergency regulations. Here, the idea is that when you issue those specific measures under model number 3, you have 7 days, and then the Knesset must respond if you want to keep using the emergency. Some examples: the police ordinance, as amended in 2005, that's the major tool that was designed for a civic emergency or a civil emergency. And in fact, this whole corona pandemic, from the perspective of the legislature, should have been addressed under this regime. So we had a full regime, and I'll touch in a second, I'll touch very briefly on the other components of this regime. There's a whole developed regime that was waiting for use, but it was never used because we used emergency regulation, because we succumbed to model number 2. And in my conclusion, I'll say a couple of words on perhaps why we did this. But there's a well-developed scheme whereby a minister, let's say the Minister of Police, or the government may empower another minister. The Minister of Police may issue or may declare a civil emergency or civic emergency, and then there are vast measures or vast powers that are given to the police and also to rescue or emergency agencies, such as the health agencies, fire agency, the whole first responders. There's another component in this regime, which is the Employment Services Under Emergencies Act, again, as amended in 2005. And in Israel, again, as of 1967, we have a whole regime whereby essential employment may be so declared, and then people have to go to work because we need the economy working. And again, the idea is that certain emergencies are declared. It's not related to the general state of emergency that Israel is under. Specific emergencies are declared, could be security related or civil emergencies. And then this whole structure of the economy is then transferred to a de facto state of emergency, whereby the right to strike, for example, no longer may be curtailed, or other regulation kicks in terms of who has to work where and when, etc. The Civil Defense Act, which allows basically the military under civil command to use some measures, was also amended in 1997 to allow to declare a special situation in the home front, whereby then the military has some powers. It's again the same idea. It's an ordinary legislation. You have an emergency provision. The minister may declare access to a certain drawer is opened, and then emergency powers are available for a short duration. And again, under the supervision of the Knesset. And lastly, we can talk about the Hazardous Materials Act. Again, if you have a spill of ammonia or something like that, it's a specific emergency. You declare it, and then you have access to some measures. What's unique about that is that it's not related to a general emergency. A minister has to do that. It is under the supervision of the Knesset after a certain period of time, and it is subject to judicial review for proportionality. Of course, module number 2 is also subject to judicial review because access to courts may not be denied, and the idea is that courts will be available to review whether the conditions were met or not. But the idea of this particular module is that you don't allow the government to act notwithstanding a statute. You prepare in advance, it's part of the legal preparedness, you prepare in advance certain measures that everybody knows, that are known a priori, and the minister may access those measures to the extent necessary if the situation requires so. Whereas in emergency regulations, sometimes emergency regulations are prepared in advance but are sealed. We wouldn't know them in advance. That's part of the problem of emergency regulation. So and I will conclude with this because my time is almost up. So why did we use emergency regulations in the current situation and not rely on module number 3, which allows for the access to emergency powers? And in fact, is a much more robust regime. It was so one explanation is that the pandemic was just not serious enough. We didn't need recourse to the more extreme measures, for example, to use the military as a supplier of goods and services. It was done only very sporadically in a couple of situations where a quarantine was placed in Bnei Brak or something like that, and then the military was invoked, or another situation was that the military was invoked in order to deal with people who returned from abroad and they needed to be put in quarantine. So the military was given a responsibility over that. But we didn't reach a situation where a full pandemic, major crisis, hospitals collapse. We have a unit, again, in the military that has to take over under this, the police ordinance and the Civil Defense Act, that there's a police unit that has to then coordinate the action of all hospitals in Israel to the extent that there is a general stress and near collapse situation. We didn't reach this. They were just waiting in the sidelines to see whether they were needed or not. So one explanation is that the current crisis will just not taxing enough for us to reach model number 3. But that doesn't really explain it, because from a legal perspective, model number 2 is more extreme than model number 3. Model number 3 allows for greater use of powers, but from a legal perspective, model number 2 is more extreme. Why? Because it allows the government to supersede primary legislation. So perhaps the reason for that is that this was a compound crisis. It wasn't just a medical crisis, it was also a political and constitutional crisis, because of the fact that there was an interim government that didn't enjoy the confidence of the public. There were 3 cycles of election. The parliament was not convened on purpose. It was not convened because of political reasons. And then things were channeled to model number 2, because model number 2 allows the government to act notwithstanding statutes. There was, at one point, there was not even a committee to review the emergency regulation. And this is where the court intervened, by the way, and said, wait, there has at least to be a committee to review the emergency regulations. So when we evaluate our current response, we have to A, recognize that it was a compound crisis, and B, recognize that several models were used. Model number 1 was used, and model number 2 was used, but model number 3, which was supposed to be the main model to address something at that scale, was not even, the recourse to this model was a minimum. Some would say good, because that means that the civilian authorities were able to do what they, under model number 1, that's better. Some would say it is a sign that something was wrong, because all the checks and balances that are built into model number 3 were not necessarily exercised. I will conclude here, unless I want to leave more time for Q&A. So I will conclude here, and Eli, the floor is yours.
Thank you very much, Amnon. It was a fascinating lecture. You know, I'm familiar with the materials, but I thought that your classification and conceptualization was new to me. So this is very good. But I have some comments. And I will start with the end. You know, you say that probably we resorted to model number 2 because of the political and constitutional crisis that we have. I'm not sure if this is the real reason. I'm not sure that if we had a functioning government, legitimate government, it would not have been a same legal arrangement. And this is supported by the way that other countries acted. Most countries, and I will talk about it in a second, you know, most countries of the world actually declared a state of emergency, general state of emergency, and took measures by various legal means, which are very, very different from model number 3 that you presented. I would say that the reason is that this crisis, in a sense, is a very, very unique crisis that has, you know, applications, very broad applications, both on the whole territory nationally and on various aspects. But it's not like an earthquake or a crisis which needs, you know, an immediate, I mean immediate intervention and decision-making, where to send the forces and so. So this is an interesting type of crisis that we haven't seen before. And maybe that's the reason that in many countries in the world, the resort was to model number 3, the emergency regulation. I want to say a word about other countries in respect to our model and to what happened in Israel. You know, I'm not an expert on other countries, but from some comparative research, it's interesting to compare Israel to Italy on the one hand and to Britain on the other hand. In Britain, as you said, the first model was used. Everything was actually achieved by very swift legislation of parliament, which delegated powers to various authorities and enforcement agencies, resulting with probably not very different situation or orders, specific orders, substantive orders, and maybe even more extreme orders or limitations of freedom than in Israel. And so this raises the question whether, the legislative path in such a situation in which the legislator is convened very quickly, there is no real time for deliberation, would not result with very similar results of emergency regulation. Italy, on the other hand, and this is something very interesting, Italy doesn't have an emergency constitution. There is no general declaration of emergency which enables the government to act, but the government is empowered by the constitution to act during emergency without a declaration by issuing decrees. So it's actually very similar to our model without the declaration of emergency, and maybe it's abused by our parliament. And in Italy, again, very drastic measures were enforced by these decrees of government, which are even more fragile legal-wise and human rights-wise from ours, because some of them are even immune to judicial review. What is also interesting, and I think that this is something that we have to delve into in the Israeli case, based on the Italian experience, what happened in Italy is also local initiatives of governors of provinces, and Italy is not a federation. It is a unitary country in which there are powers to districts, but it's not a real federation. But there were orders by provinces and even mayors, also based on local and provincial emergency powers that negated the central government orders, actually usually more extreme restrictions. And this whole structure maybe is more messy than ours, but it's an interesting question whether, and here also, in Israel, we had some kind of a different decision-making, for example, from opening schools by the big cities in Israel, negating the government orders. And I think this is also an interesting feature of this specific case of emergency. Last point, with regard to the theoretical background that you gave in the beginning, I'm going from last to first. I would correct, you said that the difference between emergency and extreme condition is that emergency we operate within the rule of law, and extreme conditions we operate outside the rule of law. I think one should distinguish between extreme condition and emergencies on the basis of the substantive situation. Emergency is something that we can prepare and forecast, and extreme conditions are something maybe like this pandemic, but we can debate about it. This is not the case in East Asia, in which this was expected and prepared for, but extreme conditions are something that we didn't envisage and predict, and we didn't have any drawer legislation or orders. And the distinction between operating within the rule of law or outside the rule of law is not fully corresponding. The first distinction between emergency and extreme condition, you can operate in emergencies outside the rule of law, and you can operate in extreme condition within the rule of law if, for example, like in Italy, there is a very, very blank empowerment of government in cases of emergency without specifying what is emergency to issue decrees. And whether this is within or outside the rule of law is something that we can debate, but there are of course many examples, for example, in the US, of operation clearly outside the rule of law, and whether this is extreme or emergency is something that we can really debate about. Amnon.
Thank you, Eli, for these insightful comments. So I will start from your last comment, and I'd say that the question is, why do we care about the rule of law to begin with? So to the extent, and this is another conversation I see Nadav here, this is a conversation I also had with Nadav in previous iterations of this development of this conceptual structure. So if what you care about is that there's just a blanket empowerment that says, whenever you need, you can do whatever you need, which is just a residual power. Let's call it the prerogative, right? Where you can just say, you know, in cases where things are really bad, you can use whatever you may feel is necessary to address so then we lose so you operate within the rule of law. So technically speaking, you don't act outside the rule of law because there is this blanket empowerment. But I think that to the extent there is a rationale for the rule of law, then these very broad general empowerments are basically a signal that you are in a sense of the rationale. You're actually acting outside the rule of law in the sense that you don't have a specific enough legal empowerment. There has to be a degree of specificity so that the whole rationale of the system would work. Now, granted, I realize that what I just said is maybe controversial. Others may say, well, you have to distinguish between a situation where you have the general empowerment and where you have no empowerment at all, or maybe you're acting contra legem in the sense it's a law that prohibits this, and nonetheless you do this. And I agree that contra legem is an exercise of power against a specific legislation. Is an even more extreme condition of an extreme condition. But nonetheless, I think that we should be careful to distinguish between operating within something that was forecasted and therefore there is some specificity in the law, and something that hasn't been forecasted and therefore there's no distinct specificity in law, and therefore almost by definition you're acting outside any you don't have any legal leverage, any basis, any virus, any whatever you want to call it, any specific prescription by law that guides your action other than do whatever is necessary. Okay, but that's a theoretical debate we can have as part of a jurisprudential question of what is law, because this is what we're acting. What is can there be a legal norm that says do whatever is necessary whenever you feel or you think or you have some reason to believe that it is necessary? Is this law or is this some general? Okay, fine. But you had, and then now I'm going to switch very quickly to your other comments, which I think are most helpful. The question with respect to other countries is actually I think it's most illuminating, because look at what happened in Sweden, for example. The idea in Sweden was that you legislate a specific law that then empowers agencies to do something that otherwise they would have had to act with a specific authorization of parliament with respect to each step. Very broadly, it's not accurate what I just said, but it's close enough. In most other jurisdictions, there was something like that. Again, in Israel, the idea that you use emergency regulations is that you allow the parliament to act notwithstanding a statute. And it wasn't clear why we needed this. Recall that all the substantive norms were given by the Ministry of Health pursuant to a specific statute. What did you need? You need the enforcement components. This is what you didn't have. And on purpose, you didn't have it because you don't want to empower the Ministry of Health to have control over the police. It's a functional separation of power from a previous lecture that we've had that is very important to maintain. So I think that other countries haven't recourse to what we see as emergency regulation in the sense of empowering governments to act notwithstanding legislation, rather than there was some specific legislation that allowed the governments to use emergency measures, but we can look closer to that. Why is this important? It is important because if we want to compare, we have to compare apples to apples and oranges to oranges in order to then assess what is how the system is resilient or not resilient in the sense of pressures, anti-democratic pressures, the work of Stefan, or what is more, what works better under emergencies. Your point here is most prudent, I think. Sometimes the presence of parliament may not generate this extra layer of anything, either protection of rights or a more nuanced, more rational address of the disaster, because the parliament has to work quickly. They don't have enough information. They just say to the executive, okay, what do you need? We'll give it to you. And that's it. This is the example this is a scenario that you alluded to. It could be the case. So I'm not necessarily saying that, that it makes such a difference, but it may make a difference. The Israeli example suggests that it made a difference. So whenever the emergency regulations were put before the parliament, all of a sudden there were very, very persistent questions of, why do you need this? Are you sure you need that? For how long do you need this? What are you going to do with that once we give it to you? Etc., etc. So the parliament actually, the idea that parliament then, in a weird way, the fact that we used model number 2 alerted the parliament to the fact that, hey, this is really unusual, and therefore maybe we have to look closer before we grant the powers. So I think it does make a difference, but we can talk about it. Last point that I want to make, actually 2 points. You talked about local and central, and I think you're right. I didn't touch this at all, because Israel is a unitary jurisdiction, but still there were differences among municipalities. What is interesting, just to broaden your point, to strengthen your point, we had a very interesting webinar in Hebrew, unfortunately, that talked about Corona and employment. What did the Corona crisis do to employment law? And one of the unique things that wasn't discussed in our webinar was that in the US, interestingly, it was not only that there was a vast amount of differences between different localities, counties, states, of course, the federal government, but the main factor, the main regulators in the US at the beginning were actually the employers, big employers, large employers, because they said to the employees, you have to abide by those internally legislated regulations. Otherwise, you lose your medical insurance. So universities and others basically said there's a virus, so please work from home. And then the state followed. So you're right that the locus of regulation, not just at the national level, is very important to detect. And lastly, I want to make a point about human rights. Again, this lecture was not about the human rights. It's a structural lecture. So it was about the institutions and about typologies of regimes, of legal regimes. And the question is, does it make a difference? Does each model make any difference with respect to the degree of protection, actual or de facto degree of protection of human rights? And it's a good question. I don't know yet. You would expect, following Stefan's very interesting lecture, that there will be some regimes with lower degree of protection of human rights, but very, very good experts who may do better in fighting pandemics or other national disasters, short term. You then expect some democracies to deal with such crises while protecting human rights better. And then you would expect some non-democratic regime, a lot of non-democratic regime who would do worse on both counts. They wouldn't do a good enough job to protect against the pandemics, and they wouldn't do a good enough job to protect human rights. Why is this my stipulation? Because human rights, by definition, entail an element of risk. You protect rights. When you protect rights, you incur a certain risk that you're not following the most utilitarian public policy. Because if there's a debate of what is there's a margin of errors, you're supposed to err on the side of human rights. A state of emergency is unique, whereby the balance is not so clear. But again, I don't know which of the three models yields a better result with respect to human rights, and that's we should consult the people who actually do that kind of work and talk and develop methodologies to evaluate this. Okay, I'm done. I talked enough.
No, it's very, very fascinating. And I see that we have Nadav and Rotem, but maybe before that, a short rebuttal. A few points. One is the East Asian model, which we didn't mention so far, which I think reflects two things. One is that the drastic or the draconic degree of measures is, of course, a function of preparation. This is why, preparation to emergency is such a crucial stage, since those countries were much better prepared in terms of tests and the speed of results of tests and applications which did not require a secret service or police to enforce, but people were incentivized to use this application. Without an application, you cannot get into the mall. Most of these countries fared much better, both in terms of fighting the virus. The death toll there is much less, certainly per population, than ours. And in a sense, they violated the freedoms, human rights, less, because there was no, in some of these countries like Taiwan, there was no general lockdown at all. People went to work. It was very, very focused and local, which actually raises also other questions about, equality and stuff like that. But this is really beyond the scope of this session. A second point with regard to Israel is, from a chronological perspective, it's interesting to see that until the 15th of March, all the extra legal measures were basically orders of the Director General of the Ministry of Health. And they were enforced, by the way. I was in isolation or in home isolation because I came back from abroad, and I was phoned in every day to make sure that I'm at home. So they were enforced, and the shift on the 15th of March from this legal measure to emergency regulation, I think this was the date the first emergency regulation was issued, was perhaps the result of the transfer of, coordinating and managing the crisis from the Ministry of Health to the Prime Minister's office. And in a sense, it could have been continuation of these orders of the Director General. So I'm not sure with regard to whether the enforcement really makes the difference between the first and the second phase of the management of the crisis. And last point with regard to our I think the theoretical debate about whether operating is within or outside the rule of law is really the essence of our center, and also of the issue here, how countries and societies fare in extreme conditions. But according to your declaration, almost every country operates outside the rule of law. If you look at I think Article 16 of the French Constitution, which says in a state of emergency, the president can do whatever he wants to do. He has to consult. If you take into account prerogative power of the Queen or the President of the US, basically, many countries operate actually outside the rule of law. And this might be an interesting project to examine comparatively how many countries really operate within the rule of law. And I suspect that it will be minority of countries.
Needless to say, I have some rebuttals to the rebuttals, but I suggest maybe we take some questions, and then I can reflect on your points as part of replying to the questions.
Okay, so Rotem, the floor is yours.
So thanks, Amnon. It was very interesting to think about these models. I haven't really thought about emergency powers and laws through these models. So it was very informative. My comment is sort of a follow-up on Eli's previous last comment about sort of emergency operating within the rule of law while extreme conditions operate outside the rule of law. So I was also a bit surprised by this, because there's a lot of literature that actually views emergency and law, or the rule of law, as two sort of distinct categories, which I completely agree that they're not. But I also very much agree with Eli that at the very least, dealing with emergency can easily be done outside of the rule of law. And I think that part of the reason for this is that the two categories of sort of emergency on one hand and extreme condition on the other hand seem to me to be quite fluid. And extreme conditions can turn into emergencies and sort of more regular or normalized emergencies quite easily. We can see this even with the coronavirus. And at that point, the fear is, of course, that it has the question whether we go back to the rule of law has a lot to do with the goodwill of the government and the legislator. And so we easily, I think, see ourselves in this sort of situation that I think is what Elia described in his comments. So just one more thing to think about, whether these categories are truly two distinct categories, emergency and extreme conditions, or whether they're sort of can fluctuate into each other very easily.
I think that Nadav points connects to Rotem's remarks, so maybe we give him the floor and then you can answer both. Nadav writes, it seems that the models are mutually exclusive. At least the legislative model, the third, seems to assume a legislative monopoly. Emergency regulation, especially contra-legum regulations, seem antithetical to this model. What do you think on the relation between these two models? This is first question. A second remarks, what do you think about the role of the courts in the apparent clash of models? How should the courts interpret the relevant constitutional and statutory provisions?
Okay, so I will address those questions as they came. So with respect to Rotem's point, which relates to Eli's point, I will start actually with Eli's observation of to what extent countries actually operate within or without the rule of law. So the question then becomes, to what extent do countries, or we should be more precise, do agents of the countries, it could be the president, the crown, right, the authorities within the country or within a certain jurisdiction, to what extent do they exercise or rely on those blanket authorizations? To the extent we will find that many countries, on many occasions, rely on those blanket authorizations of do whatever you think is necessary for the good of the country, then I have a problem, because then fewer countries operate within the rule of law. But then my criticism, I think, has a bite, because why do we need the rest of the why do we need a legal system if basically all you have to do is to say, just do whatever is good for the country, because you have this constitutional power to do so. So you don't really care. You don't need to necessarily care about all the specificity of all legislation that tells you have to do this and consider that, and you can't do this before you looked into that. I just do whatever I was elected. Let's say I'm a democracy. I was elected, and then I just do whatever I think is good for the country, right? So I think I would hypothesize that the recourse to such blanket empowerments is actually very rare, and it is an indicia that you're bordering the end of the law, the end of this legal space, where the only hook you can find for your legal action is this very broad and general empowerment that says, do whatever is necessary under this condition. So I think it's a signal. It's like what Rotem asked, whether these are a clear cut. There's a clear cut. I see it as a space, so that the dense legal space of law, emergency becomes an even denser law. And then as you move out, there are some markers, such as that's your last hook before you go outside. And one of the last hooks is this very general empowerment of do whatever is necessary, which in my vocabulary is actually you're stepping outside the rule of law, because that's the only hook you have left. Otherwise, you better use a more specific hook to hang your legal action on. That's the way I would see it. And it's true, what Rotem says is absolutely true. How does the legal space operate? It operates when sometimes you have to go where the law is very sparse, and all you have is this sort of like really vague authority, if at all. And what do? If you care about the rule of law, you legislate. Sometimes you do it retroactively. This is the Oren Gross model of do something outside of law and then legislate backwards. So you legislate either backward or forward, and then you occupy the legal space by legislating. This is how you, or enacting norms under the empowerment that you have. This is how you operate. But it's a more geographical or law and geography type of understanding of law and social space. but I would say that there is a distinction, a paradigmatic distinction, whereby sometimes you act without sufficient specificity in law that tells you what is the basis of your power, what are the limits of your power, what are the purposes, what is the proportionality, all that. If that is missing, then you know you're actually outside the rule of law. But you know that's again, it's a jurisprudential debate, but it's also an empirical debate, because we do have to see, as Eli said, what are the results from other countries? To what extent is this invoked? The idea of the very general empowerment invoked in other jurisdictions. With respect to the more technical question of was there enforcement or not, and again, this is Eli's question before, but it was also echoed by Rotem. We have to distinguish between enforcement and enforcement. If the police calls upon you to say, "Are you abiding?" The Ministry of Health, if you look at the 1940 statute, the director there can do something like that. So the police may aid, but to the extent that then the police will knock on your door and arrest you if you're not there. That is a power that the Ministry of Health doesn't have to empower the police, right? So the Minister of Health cannot order the police to use police power, not just calling, because when you call, it's a different type of enforcement, right? So again, we have to be, this is the point I wanted to raise, or part of the rationale I thought a lecture like this is important, is not only so that we have a better idea of the typologies and the pluses and minuses of each model and how to think about it, but also so we can, when we do comparative research and we talk about enforcement, what do we mean by enforcement? Because if enforcement is just, oh, I check on you, I call you, and then if you answer, that's fine, and if you don't answer, that's also fine. The General Security Service, for example, sent you a text message saying you should self-quarantine. They could also send you another text message saying, have you self-quarantined? But that's it. To the extent you want them to use the police to enforce the text messages and then go and arrest people that upon receipt of the text messages did not self-quarantine, you need a special, this is why you need a special measure of enforcement. So again, I think that we have to be more precise in terms of how the pyramid works when it comes to the decree at the very last. At the very end of the pyramid, there is this place where the law meets the individual person through a police officer or through another agent of the state with actual power over that individual, or that citizen or resident. And this is where the rubber meets the road. And this is why you need sometimes those special empowerment. And this is the rationale for model number 3. The rationale for model number 3 was, we don't want to use emergency regulation in order to empower the Ministry of Health or the Ministry of Defense or some other ministry to have access to other agencies, not usually under his or her empowerment. So we will use those special drawers for specific emergencies whereby we navigate this through the government. So that's a different type of model. One last comment with respect to Taiwan, East Asia, what Eli said about East Asia, and again, I think we have to distinguish within East Asia. So Taiwan is very different from South Korea. South Korea was prepared, but operated on a different model whereby all surveillance measures were enacted, including cameras, credit cards, GPS, everything. And then you may reach a better solution with respect to fighting an emergency or fighting the pandemic, but you pay a heavy price in terms of human rights, I think. And therefore, the overall balance is much more complex than, let's say, in Singapore. And again, in Singapore, it's more difficult because it's not really a true the democracy in Singapore is not really a democracy under some definitions. And Taiwan is yet another situation. So I think we should be more precise when we talk about which South Asian example we're actually talking about. And again, the starting point is that democracies that protect human rights may fare slightly worse than a jurisdiction that has the best experts and was best prepared, but otherwise would do better than everybody else. And even with respect to those countries that had the expert in the preparedness, in the long run, they would do better. Why? Because of the commitment to rights. The idea is that those jurisdictions will not succumb to authoritarian regimes, right? So that's the idea. That's Stefan's basically notion of why do we care about the relationship between rule of law, human rights, and emergencies. But again, that's an empirical question, and we have to make it to see whether that pans out and whether each of those models actually make a difference with respect to the way it may pan out. I didn't answer Nadav's question. So I will do so very briefly. It seems that the models are mutually exclusive. At least the legislative model seems to assume a legislative monopoly. Well, there is a legislative monopoly, but the monopoly is exercised by empowering the minister or the agencies to issue bylaws, right? That's the idea. Emergency regulations, contra legem, the idea is that still you have legislative monopoly in the sense that the government may not use this unless empowered by the basic law, right? So you act within the rule of law, but you split the government all of a sudden for a duration of 3 months may become the primary legislature unless the legislation is protected. The role of courts, wow, that's a very different question. It relates to the other lecture of judicial review under emergencies. So I have to defer to the other lecture because opening up what is the role of court under each of those models require us to revisit the previous lecture of judicial review under emergencies. So I beg to point to the other webinar we had on this question.
We have another few minutes, so if anybody wants to ask a comment, please raise your hand. And if not, I'll return to your answer now. Two points which are very interesting. I think one is the human rights point that you mentioned. I think this crisis puts the human rights issue in a different perspective. You said that Taiwan was different from South Korea, from other, but none of these Southeast Asian countries, including Japan, had a general lockdown. It was all focused on specific areas. The economy was disrupted much less. There was no general stoppage of the economy, and not even 30%. In all of these countries, they differed from each other. And this was at the price, as you said, of a very, very high degree of surveillance, but not by secret services, but by incentivized voluntary pre-prepared application. And you know, it sheds different light on our situation, and you know, whether our outcry about the enforcement or empowering the police and the General Secret Service to have this technological surveillance, had we known that the price is lack of general lockdown and lack of collapse of businesses and individuals, you know, it would have been a different perspective on human rights, which is quite interesting to think about in the future. And the second point, I think it was very good that you mentioned Oren Gross theory that justifies or legitimizes the operation outside the rule of law with the fact that retroactively the people will decide whether this was justified, legitimate or not, and will topple you down if you exceeded the powers that are granted to you. And on the basis of what's happening now, especially in the US, I must say, this rationale, you know, that people afterwards rationally outweigh, you know, your action and your violation of human rights, and whether you achieved efficient fight in the emergency, and will judge you on that basis. Well, a lot of question marks.
Yes. So first about oil growth. So I think that one of the most important things that we have to consider here is rationality under emergencies, or under stress, let's call it, under crisis, because the word crisis encompasses both emergencies and extreme conditions. So rationality under crisis, I think, is also something we should pay attention to, especially if we care about the models, because the models presuppose different kind of incentives and rationalities. It raises the question: who do you trust more or less under what type of an emergency? So the original British model starts from the position that you will trust you just trust your ministers. So, and you trust your parliament, and that's it. You trust them. And just like you trust them in ordinary times, you will trust them in emergencies. They're reasonable people. They're British after all. How can you not trust them? Very reasonable people. They likely will continue to drink their teas under emergencies to the extent possible. And therefore, everything is under control, and that's fine. The Israeli second model says, okay, we've been under the butt of your emergency regulation. You're not so reasonable, you know, High Commissioner and all that, all these British services. You weren't so reasonable when it came to us, when we were subject to this type of emergency. This is why, while we realize we may need those powers, this is why the Israeli Knesset never, to this day, never fully repealed the emergency ordinance of 1947 and worked tediously to take some chapters out of it and legislate them into concrete laws. And this is why the idea of emergency regulation a la Israel was enacted. We don't necessarily trust those civil servants. We don't necessarily trust also elected politicians. So we have to keep some notion of checks and balances built in the system. And we may not trust them, especially in emergencies, because under emergency, we may overvalue the risk. This is why you need judicial review. That corresponds in part to Nadav's question. In part, we need judicial review because the idea is that we need judicial review because there is a risk that agencies may overvalue the risk. And it was only yesterday, I think, was it yesterday, that we heard the Minister of Health, the ex-Minister of Health, saying, this is exactly what happened. We overvalued the risk. Well, this is a classic public law theory of why you need judicial review or why you need to move from model number 2 to model, or not use model number 1, at least not to use model number 1, either use model number 2 or use model number 3, because model number 2 signals, hey, there's something really extraordinary going on, and it invites more stringent parliamentary supervision and courts to look closer. And at least it is at least honest about saying, you know, it's not business as usual. It's not just, the corona law, the general corona law, but it so happens we have, no, these are not, we don't expect Parliament to follow ordinary rules of procedures when they legislate. So at least the public should be put on notice. Now, I do want to talk about the cost-benefit analysis that you raised, and the question of whether we may want to sell our rights and buy better economic conditions or non-lockdowns or fewer restrictions in terms of the economy and sell some other rights. So the first question, of course, is whether this bargain is, so there are 3 points to be said about this. The first is whether this bargain is at all feasible. So one of course, argument is once you start to sell your privacy and social control rights, because privacy in and of itself is not neither here nor there, it's about the degree to which the state can use social control. The whole thing is that the state needs access to your data and everything so that the state can use social control. So once you start selling your social control and the state has this carrot of saying, okay, you're going to have better, financial conditions, just give us better social control, then you move from the liberal democracy model to the Chinese model, which says, we know better, the prosperity will be fine, just trust us. Or even if you don't trust us, we don't need, actually, so necessarily care about your trust so much, which is a different model. It's a better model in terms of the economy or social control or whatever. So I think that the trade-off may not be so simple in the sense of, if I just give up your privacy, it's a whole shift, it's an entire shift. This is point number one. Point number two is whether, or the critique about your point is, whether this is limited only to emergencies, right? Do you only sell your privacy under emergencies, but then when it's not an emergency, you can slide back to the ordinary liberal model? I heard you before, Eli, say that maybe the liberal model has reached its expiration date, and maybe we're moving out of the liberal model altogether, irrespective of emergencies, right? So we should be mindful of this. And the last point is whether we are making a rational choice. And this ties back to what I said before. On the basis of what can I sell, what is the rational process according to which I can decide whether, this right, okay, I'll sell it and then gain my livelihood or my employment. Or so is there a measure out there? Is there a rational way, a rational decision-making, public choice like rational decision-making, or to follow Tversky and Kahneman, we're subject to so many heuristics, especially under emergencies. So we don't want to make those kind of decisions under emergencies. We want those decisions pre-baked into the system prior to an emergency. This is part of Yaniv Rosnai's point about not amending constitutions under emergencies, etc. We want this pre-baked, so in order to protect us from ourselves, because we will be subject to the song of the sirens, and then we will not necessarily give up the correct balance of rights versus public interest under emergencies simply because we're humans and we will respond to different type of pressures and fears, and therefore, we should be very wary about using proportionality ad hoc in such an ad hoc manner.
Thank you very much, Amnon. Your last words really opened the whole world of further questions, which I hope we'll address in the future.
I think Deborah wants to say.
Can I just say one? Yeah, I haven't found the raise hand function, I'm embarrassed to say. Oh. Where is it? First of all, it was really fascinating. I want to connect to your last point and to Eli's Far East comments. Not that I am not supporting the liberal democracy model, but it's interesting that in all of the countries in the Far East, irregardless of their level of democracy, because they were prepared, because they had the experience, say, of 2003 with SARS, etc., they had technology in place that was voluntary. I mean, even if it was developed by the military, all of their tracking mechanisms were voluntary. And that made a big difference in terms of public trust. So, whereas we, in our liberal democracy, which I hope we'll maintain, had to have the Shabak trace us. This isn't what happened in the countries that in the Far East. So, anyway. You're on mute. No.
So there is a paradox here, right? You would expect more liberal democracies to care about whether you get, and in Germany, and in Germany is a clear example of that model that says, if it's not voluntary, don't use it. More people will die, may die, but you don't touch this, because the dangers really outweigh, because they had their experience with the Stasi, right? It's a different social experience. But I do want to make just just two minor comments. South Korea, again, it wasn't fully voluntary. In South Korea, some of the measures were not fully voluntary. We had a very interesting meeting in the cyber center, whereby we talked to people in South Korea, and what we count as voluntary, is not really voluntary. Sometimes it was assumed that you gave your consent, and it's not that easy. Taiwan may be different, or Singapore may be different, but South Korea again. And another point I want to make here, and again, this was raised in a different webinar that I was involved with for the Justice Ministry. One of the most interesting things that happen under emergencies is that usually in a liberal model, the starting point is some type of conflict between the individual and the state, in the sense that, and again, the US is on the extreme here. In the US, the state is the potential enemy, right? So you have to make sure that you protect against the Leviathan. But even in other the continental model, where the Canadian model, where the state is there to help you, still you have to check. You have to check the power of the state, number one. And number two, the individual is in some tension with the state, in the sense that the purpose of the state is to allow the development and flourishment of the individual. To the extent the state starts to think of the development of itself, then the individual says, hey, that's not, there is a reversal here. You're there to serve me, I'm not there to serve you. That's the initial liberal starting point. So in what happens in emergencies, and therefore there is some adversarial notion between the individual and the state, even under the continental model. What happens in emergencies is you shift towards obedience. The whole point is we really need the state for now. This is what we need the state for, ultimately. We need the Leviathan under Hobbes exactly for that. And now we should just abide by what they're telling us, because there's no room for debate, dissent, because if we start doing this now, we will all sink. We will collapse, we will all sink. South Asia is very well, culturally, is very well attuned to this notion of hierarchy, which is built into the legal culture or the general culture there. What works in South Asia, therefore, in terms of the initial adversarial position between the individual and the state, is different than the classic Western model. Even if we take the US model out, in the United States today, they have demonstration whether COVID-19 is even real, which is, wow, which is amazing. People die and there are people waving American flags of why you're doing this to us, etc. Where you know, experts do tell us, just abide, just abide. And this is because in the US, they politicized expertise, and therefore it becomes left or right, because they're all expertise, again, socially speaking, the notion of expertise was politicized. Whereas in Asia, the Mandarin tradition is the expertise can be trusted and we should just abide. And in the continent, in Israel and Canada, it's somewhere in between. So we must make sure that we don't sell our rights to dissent, and we don't give up the notion to contest social control on the one hand. But on the other hand, I fully agree with you, Deborah, that the most crucial point is prepare. Because if you're not...
That's the bottom thing. If we were, the better prepared we are, the least reason to go on
the price you have to pay in terms of human rights is much higher if you're not prepared.
If you're not
And that's a dear price to pay, because sometimes some things are irrevocable. Once you give up, you cannot return. So preparedness is not only important if you want to save lives, but if you want to save democracy. So preparedness is so important. And therefore, when we measure how well we're doing in terms of response to the pandemic, we must also measure whether, to what extent we are giving up our rights, to what extent the government is working towards voluntary measures rather than just using other types of measures. It's part of the measure of what we count as success. And I fully agree with you on that.
Excellent words of conclusion. Thank you very much, Amnon. It was fascinating. We are actually meeting again tomorrow in our regular time slot at 2 o'clock, hosting Ori Sharon, Dr. Ori Sharon from Bar Ilan University, who will talk about the next crisis, the climate crisis as the source of the extinction of the state. So come tomorrow at 2. Thanks very much for your participation and have a great day.
Goodbye.